Well, if I name my spouse and then name the trust as the contingent beneficiary, is that okay? And I hear that all the time, and the fact is it isn't. And here's why. Hi, Jeff Mersace, the Plain English Attorney, and today we're going to talk about who should be the beneficiary for your life insurance when you have a revocable living trust. This ends up being way more of an issue than it really needs to be, especially when you're dealing with HR departments and it's your group life insurance. Now, let me start with a little bit of a caveat. There are some governmental HR departments where your spouse has to be the primary beneficiary on your life insurance, and there's nothing they can do to change it. But those cases are really pretty rare when we're talking about my general clients. When you have a revocable living trust and its spouses, so it's a joint revocable living trust, if you've got a life insurance policy, you should be naming the trust to be the beneficiary. Well, why? Especially since we also will give a recommendation to make your spouse the beneficiary of IRAs and 401ks and other tax-deferred accounts. All right, let me explain exactly why. You always start with the presumption that your accounts should be in the name of the trust, that other accounts, if for some reason you don't want to move them into the trust, it's pay on death into the trust, and your revocable living trust becomes your entire estate plan. Everything's laid out. If this person dies, here's where their share goes. Here are the age limits. Here's who the trustees are. Your plan is in one compact revocable living trust, and so everything should be directed there.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
There needs to be some reason for the trust to not be the primary pay on death beneficiary. When it comes to life insurance, you have to step back and ask, is there any detriment to naming the trust rather than a spouse? Well, depending on the state that you're in, it's a small, minute one. In North Carolina, life insurance proceeds that go to a spouse are not subject to creditor claims, bankruptcy, lawsuits, any of that stuff. Creditors can't get to it. Most of my clients don't come to me and start out having huge creditor issues, because if they did, they're talking about setting up trust to avoid the creditors. Well, okay, that becomes a different discussion. It's not really estate planning. It's protecting yourself from lawsuits. So we don't typically get that. The other thing is, look, if you have creditor and potential lawsuit issues and you want to wrap things up solidly, then we're talking about irrevocable trusts. We're not just talking about naming a spouse as a beneficiary. So there is no tax consequence to naming the trust as the primary beneficiary on a life insurance policy. There is with an IRA or a 401k. Well, if I name my spouse and then name the trust as the contingent beneficiary, is that okay? And I hear that all the time, and the fact is it isn't. And here's why. You're balancing that against not knowing who's going to die in what order. Now, if your spouse passes on before you do, all right, they're still listed as the primary beneficiary on that policy, but they've passed on. So the terms of the life insurance, and I'm pretty sure I'm going to go out on a small limb and say, yeah, this is universal, but yeah, hey, there might be something different. If the spouse is dead, you go to the contingent beneficiary. But now you have to prove that the spouse is dead. So maybe it could have been several years ago. Oh, I don't have any more certified copies of the death certificate. I got to order those. It just becomes a little bit more of a pain for your beneficiaries down the road to prove that your spouse was dead. And it goes to the trust. That's it. Well, what's the nightmare scenario? Well, let's just say you've got $500,000 in a death benefit for a life insurance policy. You name your spouse as the primary beneficiary, and then you name the trust as the contingent beneficiary, just in case your spouse dies before you do. All right. You die, and then, say, 40 days later, your spouse dies. And somewhere in that policy, it says, if any beneficiary fails to outlive the person who died by 30 days, then we just go to the contingent beneficiary. But that spouse lasted 40 days. Oh, we'll write the check out to the spouse's estate, which means it all goes into probate. Why would you do that? There's no benefit to naming the spouse as the primary beneficiary, except for potential lawsuits and creditors and whatnot, and naming the trust instead. Then it doesn't matter who dies in what order and how far apart. Look, it's going according to your plan. And when we set up joint revocable living trust for a couple, the survivor's in charge of everything. So there really is no reason. So when I sometimes hear, oh, well, look, this life insurance person said, no, you got to name the spouse as the beneficiary, or the HR department. Oh, I don't know about that. Most people name their spouse as the beneficiary. No. Look, there's solid reasons to avoid that potential issue with a spouse dying after that 30-day window, but before they collect the proceeds, that you might as well name the trust. But again, that's not the same thing as IRAs and 401ks, because that's tax-deferred money and there are big tax consequences. If you want to learn more about trust funding, then check out the trustfundingcourse.com. But we also have a webinar at trustfundingwebinar.com that is absolutely free. So as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.